Well, hello everyone. Today we're going over the Tenants Agency Exclusive Contract. I'm going to walk through this contract with you, and this form is a legally binding official form and contract from the BCFSA, which stands for British Columbia Financial Services Authority. And it's also from the Real Estate Board of Greater Vancouver. This is a regular official form that we usually use to sign with a commercial tenant who's looking to lease a commercial space or property. Now, this is a draft version of the contract and form for legal purposes. Now, let's begin. Tenants Agency Exclusive Contract. This information is included for the assistance of the parties only. It does not form part of the contract and should not affect the proper interpretation of any of its terms. The Tenants Agency Exclusive Contract, when signed by both parties, is a legally binding contract. Read it carefully. The parties should ensure that everything is agreed to is in writing. The process of leasing real estate is relatively complex, and for this reason, many tenants seek the help and professional expertise of a licensed real estate brokerage. It is recommended that the relationship between the tenant and the real estate brokerage should be in writing in the form of a tenants agency exclusive contract. This will ensure that both parties will have a complete understanding of their rights and responsibilities. Each party will know what they can expect from the other and what is expected from them. This is similar to the common practice of landlords entering into a listing contract when leasing a property. Real estate brokerages cooperate with each other to bring tenants and landlords together. This cooperation will help bring you the best selection of properties which meet your individual requirements. The topic of compensation to the real estate brokerage should be thoroughly discussed. The discussion should include the amount of compensation, sources of payment, and when the payment is to be made. Realtors are trained to provide valuable assistance to tenants in the following areas: identifying desirable types of properties to lease, locating properties available to view and consider, preliminary investigation and timely information gathering, viewing properties and providing guidance and advice, selecting the right property on which to make an offer to lease, which is another document, another form, preparing a legally binding offer to lease, negotiating favorable terms and conditions, assisting in arranging property inspections and other needed services, assisting in the lease negotiation and possession processes. These and other services can be documented on a schedule attached to the contract. Tenants Agency Exclusive Contract. This contract is between the tenant or tenants and the tenant's brokerage, in this case between you, the tenant, and me, Lucy Zan Real Estate, at the brokerage that I'm part of, which is Saba Realty Ltd. Terms of contract number 1. The tenant hereby appoints the tenant's brokerage and the designated agent, in this case me, Lucy Zan, as herein defined, to find a property in the market area as defined in Clause 1C from the tenant to lease, and to assist the tenant in negotiating the terms of an offer to lease. The offer to lease contract and form, which will be signed later on between tenants and landlords. B. The term of this contract shall commence on, usually, the duration of this contract lasts for about 3 months to 6 months. That's the usual time frame. However, there could be a different duration depending on the situation of the tenant. It could last up to a year. And unless renewed in writing, shall expire at 11:59 p.m. on the end date of the contract, provided that the term will terminate if the tenant's brokerage and the designated agent are unable to continue to provide trading services to the tenant as a result of Part 5 of the Real Estate Service Rules. The market area means that area located within the perimeter boundaries of the following areas, all within the province of British Columbia. Now, the market area, is a flexible and creative part of the contract. It could say from number 1 to number 1000 of Street ABC, or it could encompass a neighborhood, for example, the Fairview neighborhood in Vancouver. So this part is flexible and creative. It differs depending on who's writing it. Now, 2, designated agency. The tenant's brokerage designates, in this case, me, Lucy Zan Real Estate from Saba Realty Ltd., the designated agent to act as the sole agent of the tenant in respect of the lease of a property in the market area, and will designate one or more licensees of the tenant's brokerage to act as the sole agents of all landlords or other tenants who are also represented by the tenant's brokerage. If for any reason the license of the designated agent, or where the designated agent is comprised of more than one licensee, the licenses of all those licensees is suspended, cancelled, or becomes inoperative under the Real Estate Services Act, or the designated agent, or where the designated agent is comprised of more than one licensee, all of those licensees, is temporarily unavailable or ceases to be engaged by the tenant's brokerage. The tenant's brokerage will designate another licensee of the tenant's brokerage to act as the sole agent of the tenant. The designated agent will not disclose to other licensees, including licensees of the tenant's brokerage who represent landlords or other tenants, any confidential information of the tenant obtained through the designated agency relationship with the tenant unless authorized by the tenant or required by law. The tenant agrees that an agency relationship will exist only with the designated agent. Information obtained by the designated agent through the designated agency relationship with the tenant will not be attributed to the tenant's brokerage or to other licensees of the tenant's brokerage who represent landlords or other tenants. And no agency relationship will exist with the tenant's brokerage. This is quite an important part for tenants to pay attention to. The designated agent will make the tenant aware of properties located in the market area that the designated agent is aware of, which may meet the tenant's requirements, and to perform such further services as may be set out in the Schedule A if attached. Advise prospective landlords or listing brokerages with whom the designated agent is negotiating on the tenant's behalf that the designated agent is the agent of the tenant. If a property in which the tenant is interested is not listed with a real estate brokerage, the tenant's brokerage and the designated agent may enter into a fee agreement with the landlord, but will not in any event act as agent of the landlord. Not disclose confidential information of the tenant to any person unless authorized by the tenant or required by law, and treat the interests of the tenant and all landlords and other tenants also represented by the tenant's brokerage in an even-handed, objective, and impartial manner. The tenant agrees not to use the services of any other brokerage or licensee within the market area during the term of this contract. Again, term number 4, the tenant agrees. This part is very important to the tenants, so pay close attention to this. Now continue. B, to advise the designated agent of properties within the market area in which the tenant is interested. To provide the designated agent with sufficient information to enable the designated agent to determine the tenant's ability to lease a property. To negotiate in good faith the offer to lease for the property in which the tenant is interested, provided that the property and the terms of the offer to lease are satisfactory to the tenant, that the designated agent may disclose the tenant's identity, that the designated agent is being retained solely as a real estate brokerage and not as a lawyer, tax advisor, lender, appraiser, surveyor, structural engineer, building inspector, or other professional services advisor, and that the designated agent may have only a limited knowledge of the physical condition of a property that the tenant may be interested in leasing, and the tenant will be relying entirely upon information concerning the property's physical condition provided by the landlord or listing brokerage. The tenant understands and agrees that the information provided by a landlord or listing brokerage in respect of a particular property is not warranted by the designated agent as being accurate and will be relied upon at the tenant's risk. The tenant should make their own inquiries and investigations concerning the physical condition of a property, which should include an independent property inspection. 5. Tenant's brokerage remuneration. This part is, again, very crucial for tenants, so pay close attention to it, please. A. Prior to the tenant making an offer to lease a property, the designated agent will advise the tenant of the total amount of remuneration offered by the landlord and the listing brokerage to be paid to the tenant's brokerage for assisting in obtaining a tenant for that property. The tenant will pay the tenant's brokerage a fee of, usually this is a formula calculation, based on the final lease amount, or a lump sum agreed between the tenant and the designated agent. The fee plus applicable goods and services tax and any other applicable tax in respect of the fee. Fee plus tax equals to remuneration. If, and now the goods and services tax usually is 5% of the remuneration. If a lease between the tenant and a landlord in respect of property located in the market area is entered into during the period of this contract, or a lease between the tenant and the landlord in respect of property located in the market area which is introduced to the tenant by the tenant's brokerage, designated agent, or by any other person including the tenant during the period of this contract is entered into, within 60 days after the expiration of the term of this contract, or any time after the period described in A where the efforts of the tenant's brokerage or the designated agent were an effective cost, provided, however, that no such fee is payable if, after the expiration of the term of this contract, the tenant has entered into a similar written tenant's agency exclusive contract with a licensed brokerage in respect of the market area, and the property is leased during the term of that contract. Monies, if any, under Clause 5A shall be deducted from the amount due and payable by the tenant under Clause 5B, and the tenant shall pay any shortfall owing to the tenant's brokerage. The remuneration due to the tenant's brokerage under Clause 5B shall be payable on the earlier of the date on which the lease is submitted to the Land Title Office for registration, the date the tenant has the right to take possession of the premises, and the date the tenant lawfully occupies the premises. The tenant's brokerage will advise the tenant of any remuneration other than the described in Clause 5A to be received by the tenant's brokerage in respect of that property. 6. The tenant acknowledges and agrees that, again, this is an important part of this agreement and contract and form, so pay close attention to this. The tenant acknowledges and agrees that the duties set out in Real Estate Services Rule 30 apply only to the designated agent and do not apply to any other licensees of the tenant's brokerage who represent landlords or other tenants, and subject to Clause 3B, 3C, and 3D, do not apply to the tenant's brokerage. The tenant's brokerage or the designated agent may provide trading services to, have agency relationships with, or be engaged by other tenants, or be engaged by or to have agency relationships with landlords, unless doing so would constitute a dual agency that is not permitted by Part 5 of the Real Estate Services Rule. In the case that the provision of trading services to the tenant contemplated hereby and the provision of trading services to a landlord or another tenant constitutes or becomes a dual agency that is not permitted by Part 5 of the Real Estate Services Rules, the tenant acknowledges and agrees that the tenant's brokerage and the designated agent, as applicable, must comply with Real Estate Services Rule 65 and may be required to cease providing certain trading services to the tenant. And, despite Real Estate Services Rule 30F, the tenant's brokerage and the designated agent will not be required to disclose to the tenant confidential information obtained through any agency relationship. 7. Conflicts of interest. If the designated agent's provision of trading services to the tenant and the landlord of a property referred to in this Clause 7A as the property would constitute a dual agency that is not permitted by Part 5 of the Real Estate Services Rules, the designated agent may request consent from the tenant and such landlord to continue to represent either the tenant or such landlord in respect of the property and terminate their agency relationship with the other party. In such case, the designated agent will present the agent and such landlord with a written agreement in compliance with Section 65 of the Real Estate Services Rules, the consent agreement, notwithstanding anything else in this contract. If the tenant and such landlord consent to the designated agent continuing to act for one of them and terminating the agency relationship with the other in respect of the property, and they execute this consent agreement, the tenant hereby acknowledges and agrees as follows. If the designated agent ceases to act as the agent of the tenant, the designated agent may otherwise in the future act as the agent of the tenant in respect of the property other than the property. If the designated agent ceases to act as the agent of the tenant in respect of the property, subject to Part 5 of the Real Estate Services Rules, the tenant's brokerage may designate another licensee of the tenant's brokerage to act as the designated agent of the tenant, or if the tenant's brokerage is unable to or does not designate another licensee of the tenant's brokerage, the tenant's brokerage may refer the tenant to another brokerage for representation in respect of the property, provided that the tenant will not be obligated to accept such referral. And if the designated agent ceases to act as the agent of the tenant in respect of the properties acknowledge that a. the designated agent's agency with the tenant will terminate, and the designated agent will no longer have any duties to the tenant as agent of the tenant, whether under this contract, under the Real Estate Services Rules, other than their duties of confidentiality under Rule 30E, or otherwise, and b. the tenant's brokerage and the designated agent will be permitted by the terms of the consent agreement and the real estate services rules to continue to represent such landlord. If the designated agent's provision of trading services to the tenant and another tenant with whom the designated agent has an agency relationship, the other tenant, in respect of a property referred to in this clause 7b as the property, would constitute a dual agency that is not permitted by Part 5 of the Real Estate Services Rules. The designated agent may request consent from the tenant and the other tenant to continue to represent either the tenant or the other tenant in respect of the property. In such case, the designated agent will represent the tenant and the other tenant with a consent agreement. Notwithstanding anything else in this contract, if the tenant and the other tenant consent to the designated agent continuing to act for one of them in respect of the property and they execute the consent agreement, the tenant hereby acknowledges and agrees as follows. If the designated agent ceases to act as the agent of the tenant in respect of the property, the designated agent may continue to act as the agent of the tenant in respect of the property other than the property. If the designated agent ceases to act as agent of the tenant in respect of the property subject to Part 5 of the Real Estate Services Rules, the tenant's brokerage may designate another licensee of the tenant's brokerage to act as the agent of the tenant in respect of the property, or if the tenant's brokerage is unable to or does not designate another licensee of the tenant's brokerage, the tenant's brokerage may refer the tenant to another brokerage for representation in respect of the property, provided that the tenant will not be obligated to accept such referral, and if the designated agent ceases to act as the agent of the tenant in respect of the property, the parties acknowledge that the designated agent's agency with the tenant will terminate and the designated agent will no longer have any duties to the tenant as agent of the tenant, whether under this contract, under the Real Estate Services Rules, other than their duties of confidentiality under Rule 30E or otherwise. And B, the tenant's brokerage and the designated agent will be permitted by the terms of the consent agreement and the Real Estate Services Rules to continue to represent such other tenant. 8. Collection, use, and disclosure of personal information. The tenant hereby consents to the collection, use, and disclosure by the tenant's brokerage and by the managing broker or brokers, associate brokers, and representatives of the tenant's brokerage, collectively the licensee noted below, and the real estate board in whose jurisdiction the market area is located and or of which the tenant's brokerage or licensee is a member, of personal information about the tenant, for all purposes related to the provision of real estate services by the tenant's brokerage and to the tenant, including but not limited to locating, assessing, and qualifying properties for the tenant, advertising on behalf of the tenant, and providing information to third parties, including but not limited to lawyers and notaries public, financial institutions, government departments and agencies, and building inspectors. For the purpose of placement in the database of a multiple listing services of a real estate board, if the property leased by the tenant is listed on such multiple listing service, for compilation, retention, and publication by such real estate board of any statistics, including historical multiple listing service data for use by any persons authorized to use the multiple listing service of such real estate board, for enforcing codes of professional conduct and ethics for members of real estate boards, for such other purposes as are appropriate in a connection with the listing, marketing, and selling of real estate, for all other purposes authorized in this contract, and for the purposes and to the recipients described in British Columbia Real Estate Association's privacy notice and consent form. The personal information provided by the tenant may be stored on databases outside Canada, in which case it would be subject to the laws of the jurisdiction in which it is located. 9. Miscellaneous provisions. Period or date of expiration of this contract includes the period or date of expiration of any written extension. Offer to lease includes an offer to lease or an agreement to lease. Interpretation of this contract and all matters concerning its enforcement by the parties shall be governed by the laws of the province of British Columbia. The parties acknowledge that this contract fully sets out the terms of the agreement between them. This contract shall be binding upon and benefit not only the parties but also their respective heirs, executors, administrators, successors, and assigns. This contract shall automatically end if the tenant's brokerage ceases to be licensed under the Real Estate Services Act. Property means a leasehold interest and may include a business and the goodwill and assets of it. An interest, partnership, or share in a business or in the goodwill and assets of it, or a manufactured home, plus any other real property designated by a landlord. 10. Agreement. The tenant acknowledges having read and understood this contract, that it accurately describes the agreement with the tenant's brokerage, and that the tenant has received a copy of it. Where the tenant is comprised of more than one party, the obligations under the contract of each and every party comprising the tenant shall be joint and several. Signed, sealed, delivered, date, tenant's signature, tenant's printed name, witness, designated agent signature, in which case would be Lucy Zan, and managing broker's signature. This is the attached Schedule A, which could include any information or any amendment based upon the pre-written contract aforementioned and aforeread. Now, this is a draft version again, and this is by no means an act to disrupt any current agency relationship that's already established between whoever out there, a tenant, and their existing real estate agent, if they have already entered into one. And this video is for the general information of the public. It's for educational purposes. It's based on a draft version of the document. And this video session also is not intended to induce any breaking of the existing agency relationship between any tenant and their real estate agent. So as of today, which is September 7th, 2023, that's the date for today, and this form and contract changes from time to time, updates from time to time. So this particular video and this draft version of the contract and form is for educational purposes only. It's not for the intention or purpose of establishing any kind of agency relationship between Lucy Zan Real Estate or Saba Realty Ltd. It's for the general educational purposes only. Thank you for sitting around and going through this contract and agreement and form with me. I look forward to doing business with you. My contact information is 1-888-647-4488. My local number is 604-445-2772. You could also email me at info at lucyzenrealestate.com. And make sure to check out my website at www.lucyzenrealestate.com for many other goodies. Thank you again. Looking forward to doing business with you.